that they failed to identify particular products and simply used the mark in relation to various tabs. And I wanted the court to be aware this wasn't just simply a sort of forensic point about them failing to do the decent job in terms of solicitors not going through the process and ticking the tabs and then getting the relevant documents. The court could legitimately infer there was a reason why they didn't do that. Because if you go through certain of the tabs, you find that some of the various products they specifically were relying on for the trial judge, and now banned in front of you, were branded with trademarks of third parties. I just want to show you one page which makes that point good, and that's in the supplemental bundle 2, behind tab 5, and this has obviously been relied. This would actually be relied upon for them for the purpose of their appeal strategy, that's now been abandoned already. SP2 at page 76 behind tab 5. This was being relied on in relation to use in relation to footwear, the Athleta combination mark in relation to footwear. And you'll have seen when you've gone to this page, in fact, in the middle, there's a white sneaker or trainer shown in two elements. The eagle-eyed amongst you will see that's got an N on it. And if you think I'm looking at the Turin shroud, bear with me, because I'm going to show you the next page to make that good. N is a New Balance trainer. And you see below that, animation for Birkenstock and shop Birkenstock. So they were actually selling under footwear branded goods, not Athleta goods in any way whatsoever. And to make the New Balance good, if you go over the page to page 77, you see the N, which is the trademark of New Balance, on material identical sneakers, but this time they're in the grey and white colourway rather than the all-white colourway. So it was legitimate for the court to be very sceptical that if you don't show me the particular products in relation to a particular mark, then I can't draw any inference that there's been genuine use.
Is the one on page 90, which you showed us?
Yes.
Is that other trademarks as well, or is that all Athlecia or Athleta stuff?
Page 90 is very difficult to know because
there's a sock there with some writing on it.
Exactly. And I can't give it, well, I'm not going to give evidence of what that is, but it doesn't seem to be Athleta. But I'm not saying that it means that I can't say that it had a particular trademark on it. And I'm not going to say in relation to any of these, on the page, you see at page 90, there's a specifically trademarked good. What there certainly isn't is any good which is marked with the Athleta combination mark. But I'm going to show you the moment it came to the judgment was actually in their favour, that even taking this account, I didn't think there was enough.
So, since we're looking at that,
yes.
Can you help me on this? If we look at the top row of images, the one at the extreme right, which is a Legend crossbody bag, and there's a symbol at the top right of the picture.
Yes.
What is that symbol?
I can't read that. It looks like a lambda. It could. I can't read that, my lord. I don't know whether your image is better.
But does the evidence disclose whether that is an Athleta trademark or a third-party trademark, or we just don't know?
No. So what happened was, as I understand it, and I wasn't there, so if I got it wrong, someone will tell me, is at the end of the day, at the end of the trial, my learned friend said, I've got a schedule of documents. These are the only documents you need to look at for the purpose of establishing genuine use. And this is one of the documents in that. So this isn't a case where you often see in genuine use cases, there's a primary supporting witness statement saying, this is the sort of use, and here are some examples. That wasn't put forward in this way. It was, here are a whole load of documents. You can infer from that there's been genuine use. And this is one of those documents.
Okay.
If I've got that wrong, no doubt someone will correct me, but that's how I understand the transcript and from my learned junior. Now, I was also making the point that there was no evidence as to how many people visited any specific pages. This was something upon which the judge observed the inadequacy of the evidence, and you'll see that in the judgment at 55, judgment 55. So this is where it gives the totality of the, dealing with the website at large. It tells us about the number of sales each year. and there were a number of UK visitors to the website generally, although it was not possible to tell which pages of the website they visited. It was therefore said to be exploiting Athleta Marks in relation to all the goods shown on the website. And that's what obviously he was being asked to consider, and he said it wasn't, for the reasons we've just been discussing. So, in our respectful submission, the reality of this is it's not a case about de minimis trade, nor indeed at the end of the day about targeting at all. Actually, it's a relatively straightforward factual case in which the appellant simply failed or did not adduce adequate evidence, neither solid nor substantial evidence of use of the marks in question for the goods in question to establish genuine use. Rather, at best, it was mere unsupported advertising use on a handful of pages from an accessible US-directed website. And given the appellant is part of the enormous GAP group of companies and had the opportunity and ability, if they had evidence, to substantiate evidence of use, to evidence traffic to the particular web pages, traffic from the UK specifically, showing specific web pages, offering the specific goods under the specific marks in question, which they could easily have demonstrated if they existed, the trial judge was correct to find that genuine use had not been established. And the more so, given the nature of the market for these goods. I mean, these are general fashion goods, and I showed you the examples in nuclei of the sort of market when you're doing general general commercial products such as this. I'm not saying it's a de minimis point, but the court required to take into account the market for these goods and ask, have I seen sufficient evidence that they're either trying to maintain or create a market in relation to these sorts of goods? And ultimately, there was no clear, precise, detailed, and well-supported evidence of the nature of the use relied on. Now, the judgment you've already seen in relation to this, but in paragraph 74 of the judgment, the judge deals with bags, and the first two, second and third sentences explains that John Lewis evidence did not establish use of the combination mark or variant on the bags. The next 14 lines address the US-directed website. So it's clear from this that the judge, taking the evidence of use at its highest, namely to assume that the combination mark on the website itself is sufficient to be use of the mark in relation to each of the specific bags offered for sale on that site. We say that's generous, given what I've shown you on the webpage. The judge found there was no sale of any such bag, and inferred that very few UK consumers considered the website targeted them, i.e. the judge could not infer that there had been any material numbers of viewers of those pages by consumers from the UK. What he was saying was these are cheap goods. If this had been targeted them, I would assume there's going to be at least some sales. There's no sales at all, so I infer actually that there was none. And in those circumstances, we say the judge was entitled to find, as he did, in the last two sentences of 74, there had been no genuine use of the combination mark in relation to bags. Now, I accept, obviously, it could be fuller and more detailed in terms of a description in relation to all of these, but to be fair to the judge, he was going through an awful lot of different categories and was just given a bundle of documents to go through and give his opinion in relation to it. And we all know a judge does not always express himself in writing every factor which influences the ultimate conclusion on a multifactorial decision, and he should only interfere in such circumstances where his conclusions are not an available answer to the issue having regard to the facts before him. And that is a paraphrase and slight quote to the Supreme Court in Lifestyle Equities at paragraph 83. Now, also in Lifestyle Equities in the Supreme Court, obviously, whether an average consumer would consider the website to be directed at him is something that the judge must evaluate and carry out a multifactorial assessment of all the relevant circumstances. Again, that's paragraph 29. I think that's at all controversial, but I should possibly show you paragraph 24 of Lifestyle Equities. That's in Authorities Bundle 1, behind tab 8, pages, beginning up at page 229, right? So I've got the wrong reference there. 224. 224. So this is Lifestyle Equities, Lord Briggs, paragraph 24, talking about the application of these principles in the context of trademark dispute through advertisement of goods on foreign websites. And then he quotes from the Court of Appeal in Merck and Merck, and judgment of Lord Justice Kitchen, with whom Lord Justice Patton and Floyd agreed. May I just ask you to pick up the bottom of that page, where they're talking about the factors to take into account. Fourthly, on 170, carry out an evaluation of all the relevant circumstances. And then we have a number of the things which my learned friend, Dr. Darby, went through this morning, all of which we agree with. And picking up the last few lines, obviously the appearance and content of the website will be of particular significance, including whether it's possible to buy goods or services from it. However, the relevant circumstances may extend beyond the website itself and include, for example, the nature and size of the trader's business, the characteristics of the goods and services, and the number of visits made to the website by consumers in the UK. And that's what the judge had in mind, and that's what he addressed when he was looking at saying whether this was targeted. No sales, therefore confirmed no one went there, and therefore not targeted. So we do say the appellant is wrong to suggest there's an identical flaw in the treatment of this, either as a matter of logic or lack of consistency or failure to take into account any material facts. Just for your notes, the judge dealt with headgear, paragraphs 77 and 78, in a material identical way, drawing the material similar inference. Formally, in their skeleton at paragraphs 11 to 17, they seek to suggest that the judge erred by considering the US website was not targeted to the UK, and thus in paragraph 20 they assert, or seek to suggest, that the judge then wrongly ignored the relevant evidence of purported use of the US website, which they say founds their basis of their ability for this court to interfere. Well, as I've shown you, we say that's a total mischaracterization of what the judge did. He specifically looked at the US website use and analysed it. He thought it was not sufficient to amount to genuine use, but also because at the highest, merely branded website use in relation to products in respect to which there had been no material transactional sales, and there was no evidence of any UK or EU consumers visiting the specific pages in question. So he was neither ignoring the website usage relied on by the appellant, nor was it incorrect of the judge to state that the very few consumers considered the US-facing website to target them. Now, as to the no de minimis rule, the appellant's skeleton at paragraph 25 seeks to assert the judge based his findings of lack of genuine use on the size of the use. As I've shown you, the judge's findings of lack of genuine use were based on the absence of evidence that the offers for sale in relation to Essence, the non-clothing goods on the US-directed website, had been seen by any material number of the relevant consumers in the UK or in the EU. This was the only rational conclusion the judge could draw in the circumstances where the US-directed website was correctly held to be primarily directed to the US consumers. Its offers were in dollars. There was free shipping over $50. And the appellant had no evidence of the numbers of UK viewers of any of the relevant pages at all. And the appellant did not seek to suggest in relation to any particular offers for sale on the website that any sales were in fact made. So we do say it's incorrect to assert the judge applied any threshold in terms of value relied on in the absence of sales in respect to goods which had held no genuine use. That is ground one, unless I can assist you further, my lords. Ground three, we've addressed in paragraphs 31 to 45 of our skeleton. And the allegation here is the judge conducted an incorrect assessment of the distinctive character of the Athleta wordmark in relation to the descriptiveness or elusiveness of the Athlete prefix. That's the ground of appeal. Now, as a general observation, the thrust of the appellant's submissions before the trial judge was that having found the Athleta wordmark to be distinctive, enough for it to be registrable, the judge must consequently find there to be a likelihood of confusion when considering the use of the Athlecia word mark, because Athlecia is highly similar, visually, orally, and conceptually, and registered with respect to identical goods. Further, the appellant asserted that the context of use was highly similar, and therefore they were saying nothing material points away from it, so there should be a finding of likelihood of confusion. Anything else would mean that a weakly distinctive mark would only be infringed if the marks and the signs were identical. Well, the fallacy in that logic is that a mark may be weakly distinctive because it's a new invented word which is made up of one component which is obviously allusive or potentially descriptive, together with an extra element, which in combination makes the mark new and distinctive, but maybe only weakly distinctive. However, if the commonality between such a mark and the allegedly infringing sign is that component, i.e. that which is obviously elusive or potentially descriptive, then it does not follow that the allegedly infringing sign will give rise to likelihood of confusion, because as the case law makes clear, where the similarity or common element has low distinctiveness, that points away from there being a likelihood of confusion. The judge took all those facts into account when making his multifactorial assessment, and was entitled to come to the decision that he did, when holding that the use of the Athlecia sign would not give rise to a likelihood of confusion in respect of the Athleta word mark. His analysis was conventional, it was in accordance with principle, and in performing that analysis and evaluation, he did not dissect the mark and signs. He took all the relevant factors into account. There's no error of law or principle in the judgment in relation to the judge's infringement analysis issue. Rather, it's a decision which the appellant doesn't like and is asking this court to repeat it de novo. We say it's not open to this court to do that, and specifically in relation to ground 3, what the appellant now seeks to contend is that the judge fell into error when assessing the distinctive character of the Athleta word mark by failing to consider the word as a whole and by failing to take into account the allegedly weak nature of the elusiveness to clothing. That's their skeleton paragraphs 31A and 31B. Two elements, and they're wrong on both counts. In essence, what they're seeking to assert, without being bold enough to say it, is the judge was not entitled to come to the conclusion that the Athleta word mark had a low level of distinctiveness. Now, addressing those 2 points in turn, the alleged failure to consider the Athleta word mark as a whole when considering it to be weakly distinctive, that is wrong. When considering the distinctive character of the Athleta word mark, the judge did indeed consider the word mark as a whole. We set out the answer in paragraph 33 of our skeleton, but could you take a copy of the judgment, please, and turn firstly to paragraph 24. What the judge had to do in this section is address the arguments that it was descriptive or lacking in any distinctive character. And in 24, he was held, there was no evidence that the mark as a whole was descriptive. Judgment 25, again, he's holding it, the mark as a whole is not a descriptor. It's both correct as a matter of logic and not criticised. At 31, the judge then holds the word mark is not devoid of any distinctive character. It's a coined word, but it alludes, the word as a totality alludes to athlete or athletics. And we say correct as a matter of logic and not in fact criticised by the appellant at trial. On the contrary, at trial, the appellant accepted that the Athleta word mark was not a fancy word, but rather had an elusive element. Could I ask you to look at supplemental bundle 1, please? Turn to tab 5. And page 91. This is my learned friend's closing written submissions. Paragraph 322, this is their written submissions. Claimants do not suggest, paragraph 322, claimants do not suggest that Athlecia is a fancy word like Kodak or the like. Some average consumers will relate it to the concept of athletes. As noted above, any such conceptual aspect is the same in relation to Athlecia. That was their own case in closing. And that is what the judge is referring to in the pre-penultimate sentence of the judgment at 161. Again, I apologise for asking you to jump around, and I apologise for doing this so speedily, but do shout if I'm going too fast. But in the pre-penultimate sentence on paragraph 161, page 157 of the bundle, Athleta's counsel quite rightly conceded does not get the broad scope of protection attributable to a highly distinctive mark such as Kodak. That's a reference back to their own position in closing. Now, the judge did not salami slice the trademark when assessing its distinctive character. The appellant relies on paragraph 159 of the judgment as a certain...
Can you help me on this? Because he says there, in order to infringe, a sign used by a third party would have to be closer to the Athleta word mark than Athlecia. But he found that they were highly similar.
Yes. Well,
so how much closer can you get than highly similar?
Well, you can get more similar to it still. I mean, we all know from office cleaning and such like that small differences may be sufficient. And so you can get closer. I was going to come address that in a moment, Lord, specifically. But he's not saying it has to be identical. It could be closer. And on the facts of this case, he said he's effectively saying it needs to be closer than it currently is.
I suppose if instead of the C you had a T.
Yeah, absolutely.
Certainly in the English language.
Yeah.
That would perhaps make the average consumer think athletics, athlete.
Exactly. You might, and he's not saying, I mean, ultimately, he's not saying it will only be infringed by an identical mark. He says, on the facts of this case, this one is not similar enough to give rise to likelihood of confusion. We say perfectly entitled to come to that conclusion.
But what do you say to Mr. Barron's submission that it was wrong for the judge to say that the only common element is ATHLE?
Yes, well, I'm going to come to that if I may, but I've got it entirely on board, and I can say he's right for him to come to it, and just jumping ahead a little bit.
Yeah, that's fine.
If I may, but I've got that in mind, if I may. I just want to run through, because the way in which it's presented orally is slightly different from the way in which it's been presented in writing, and I just want to make sure I've covered off all the bases in both, if I may. So, what the judge has done in his judgment is, in 24 and 25, I've just shown you, he was considering the inherent distinctiveness of the Athleta word mark itself. At judgment 120, he's considering the issue of distinctiveness against, again, when addressing the conceptual similarity of the Athleta and Athlecia marks as a first step in the infringement analysis. And again, he reiterates that the Athleta word mark is not entirely descriptive. He specifically rejects my client's submissions at trial that the mark as a whole would be understood by the average consumers as being descriptive, i.e. a female athlete. And he repeats in judgment 120 that Athleta would be seen by the average consumers to be a made-up word based on athlete or athletics, particularly when the mark is used in relation to activewear. And we say, indeed, that was a very fair context in which the average consumer will perceive the Athleta word mark. And I want to show you two documents in relation to that, if I may. The first one is in the supplemental bundle 1 at tab 41. And this is the witness statement of Patricia Elizabeth Gwillam, the claimant and appellant's head of franchise, account management and planning. And if you'd be so kind as to turn to page 198, paragraph 8, she describes Athleta is an Athlecia brand that started in the US. That's how she describes the actual brand itself. And secondly,
Sorry, I
Sorry.
haven't found the paragraph.
oh, I do apologise, I go too fast. Tab 41, Supplemental Bundle 1, page 198, paragraph 8, first sentence, head of franchise account management and planning, Europe and EMEA. She calls the brand an Athlecia brand. Sorry, an Athlecia brand. Sorry.
And what are you trying to get out of it?
So I'm trying to get out of the fact that using Athleta and Athlecia in relation to the context of athletic wear was something which the average consumer would do, and it was.
Sorry, you're relying upon this as evidence as to the perception of the average consumer in the UK, aren't you?
No, what I'm saying is the judgment in 120 says would be seen by the average.
Yes, but never mind what the judgment says. We're trying to get something out of this witness statement.
Yes.
And as you point out, she's head of franchise account management.
Yes.
And she seems to be here giving a historical account of the brand.
Yes.
And
Yes.
what do we get out of it?
You get out of the fact that the client themselves refers to their own brand as being something which is an athleisure brand, i.e. that they treat it as being a brand relating to a description of the market which is called athleisure. That's all you get out of it. Okay? Bear with me, my lord. There's a second document I wanted to show you, and that is the particulars of claim, which is directly relevant to this case. And that's in the core bundle at tab 17. Page 213. The pleaded case against my clients, set out in paragraph 16, in both 16A and 16B, is that they were using the Athlecia brand, including clothing and athletic wear. It's in both the particulars in 16A and 16B. So
I'm still struggling because you have a finding in your favour,
Yes.
which is not challenged, that the trademark Athleta
Yes.
is elusive of the word athletic.
Yes.
Do the two pieces of evidence that you've just shown us establish any more than that which is already conceded?
No, but they challenge directly the point I'm going to make, my lord, which is that which they set out in paragraphs 31B and 33C of their skeleton argument to suggest that before you, that the allusion to athletes is particularly weak. And we say, no, it's not particularly weak. It was directly before the court as being the way in which this mark was being used. And I have to address the case before me, Lord, which is why I'm doing it. Then, my lord, if we can ask you to go back to the judgment as at 120. At 121, the judgment then completes its overall assessment of similarity of the marks and the signs. And at 122 to 123, the judge assesses the similarity of the goods and services. From 124 onwards, the judge was considering the global question of likelihood of confusion, initially setting out the relevant law addressing particular facts. At 156, which is the start of the core passages my learned friend relies on, he's starting the analysis of the likelihood of confusion by taking into account the extent to which a registered trademark is highly distinctive or not.
I'm sorry, which paragraph?
Sorry, judgment 156.
156.
Bottom of page 154 of the core bundle. Now he does so by correctly quoting from this court's decision in Lifestyle Equities, and paragraph 36 of Lifestyle Equities at the top of the page. He sets out the interdependency principle, higher distinctiveness, great likelihood of confusion. Then he also sets out what this court says about the converse. And at 38 and 39, the lower distinctiveness, narrow protection, i.e. pointing away from a likelihood of confusion, and specifically in 39, lower distinctiveness can arise in a variety of ways. And he quotes by Lord Justice Arnold in two particular ways. Firstly, that the mark is elusive itself. That's the first two sentences. And secondly, there are other ways, including if the only similarity between the trademark and the sign is a common element which has low distinctiveness, that would point away from the likelihood of confusion. And that's the fourth sentence. And that's the context in which the judge then considers paragraphs 157 to 159. 157, the judge correctly observes that both the Athleta mark and the Athlecia sign as a whole would be understood by the average consumer as based on the words athlete and athletics. And they're also used in relation to clothes aimed at athletes. And this is correctly addressing the entirety of the marks in question and also the goods to which the marks are being applied. It's correct, and indeed we say common ground between the parties at trial, as I've already shown you. Exemplified examples are then given at paragraph 158. Then at 159, the judge addresses the common element, which a judge was required to do as a matter of law following this court's guidance in lifestyle equities. His judgment that the common element was athlete has found that the average consumers will consider that to be a reference to athletes and athletics. This passage is not supporting the appellant's proposition, which they've put in writing, that the judge was holding the entire Athleta mark as lacking in distinctiveness, or the entire mark as being totally elusive, nor is it evidence that the judge illegitimately salami sliced up the Athleta mark in order to consider that one part was elusive or not. Rather, because lifestyle equities requires the judge to consider whether the common element was of low distinctiveness, because if it was, that would point away to a likelihood of confusion and to a mark which enjoyed a narrow protection against the sign, as stated in terms by this court in lifestyle equities at paragraphs 38 and 39, which the judge properly set out in his judgment at 156. Now, just for avoidance of any doubt, when the judge refers to a descriptive term in the last sentence of 159, we say it's clear that the judge was intending to include elusiveness within that meaning, because if you look at the middle of the paragraph where it explains that the common element will be seen by the average consumer to be a reference to athlete or athletics, and therefore you should pay close attention to the suffixes. And then at 161, the judge goes on to do the final overall analysis. And what's clear there is considered the Athleta wordmark as a whole to be only weakly distinctive, as indeed he's held the Athlecia mark to be so. So we say there's no error principle here, and conventional analysis consider the distinctiveness of the Athleta wordmark as a whole and separately consider the common element when addressing the question of likelihood of confusion as he is required to do. Now, the point that my learned friend made orally for the first time this morning is to suggest that the judge erred by finding the only common element to be athlete. Well, to be fair to the judge, that was the common element. The suffixes are different. The lengths of the word are different. Sure, they have an A at the end of both of them, but the material commonality between these two marks is that first 5 letters, athlete. And that's what he was addressing. That's the identity, and that's the core commonality. And that's what he was entitled to do. So that, I hope, picks up the point my Lord Justice Singh had in mind in terms of the commonality point. There are 3 short points I want to make in relation to ground 3 in terms of observations, given the way in which my learned friend put it orally this morning. Firstly is that the judgment from lifestyle equities as set out in paragraph 156 of this judgment is not dependent, the law there is not dependent on there being a crowded market. It applies as a matter of principle. The Athleta wordmark will not be anything other than weakly distinctive for clothing in circumstances where the clothing is described as athletic wear. Secondly, and as alluded to in my learned friend Skeleton argument at paragraph 36, they suggest that the judge erred by failing to take into account the highly visually similar nature of the Athleta and the Athlecia marks. Well, that's wrong in terms. The judge has that expressly in mind and refers to that specifically in the third sentence of the judgment at 161. And then finally, picking up my Lord Justice Arnold's point, insofar as it should be said that a weakly distinctive mark by my learned friend would only be infringed by an identical sign, we've addressed that in paragraph 43 of our skeleton, but the office cleaning case is just merely illustrative of the same principle that I'm sorry.
Explain to me how you can rely on a decision of the House of Lords in a passing off case from the middle of the 20th century in circumstances where we are applying EU-derived law as to trademarks.
Because, my Lord, in that passage which we've quoted, is specifically referring to the doctrine coming out of trademark law, and we say the same principle still applies today, because what one's got to consider is when one looks at the mark and the sign, is it going to give rise to a likelihood of confusion? Are they sufficiently similar to be confusingly similar? And I'll show you the passage we have in mind. And
there's two problems with that, which if you're going to pursue this, you'll need to address. Firstly, the case law of the Court of Justice, which establishes that the test in this context is the risk of confusion.
Yes.
Which is different to the passing off test.
Yes.
Secondly, all the case law from the Court of Justice and the General Court, which tells us that even if you have a weakly distinctive mark, you can't place the threshold so high that it's only infringed by a sign that is identical.
Yeah. And I'm not going that high. I'm not going that high, and I've said that already to you, my Lord. I'm suggesting to you the reasoning given by the House of Lords in office cleaning is just as applicable here, in that when you have an element which is the common element which is highly elusive or descriptive, small differences here, small differences to the suffix, are likely, as the underlying reason for my Lord's own judgment, as he said out in Lifestyle Equity, are likely...
That's firmly based on the relevant case law.
Yes, but the underlying policy...
So if you're relying upon what was said in Lifestyle Equities, fine,
yeah, because
that's firmly based in the EU case law. Where I'm having more difficulty is your attempt to go further by reference to the common law of passing off, which, to my mind, has a great deal of difficulty in being relevant in this particular context.
Let me show you the passages, Lord, and then I'll shut up. Passages in office cleaning, Province Bundle 1, behind tab 1, page 6. And the passage I've asked this court to read are on page 6 of the bundle, lines 22 through to lines 35, and similarly again, lines 47 over the page to line 4 on the following page. And that also chimes with what Lord Wright had in mind and said expressly at page 4 of the bundle, lines 25 through to lines 32. And I am not trying to go beyond what's said in Lifestyle Equities, but I'm saying it's a useful touchstone to appreciate why what's said in Lifestyle Equities is solid in principle, because it has some decent, rational understanding. Using something which is merely a descriptor or something which is highly elusive, then if you make small changes to it, it is unlikely that that is going to be something which falls within the scope of the statutory monopoly. Now, that deals with ground 3. Ground 4, the judge allegedly conducted an incorrect assessment of the visual similarity between the Athleta combination mark and the first Athlecia combination. And what they say is the judgment is illogical and inconsistent. And the assertion is that because when the judge considered the Athlecia word mark against the Athleta word mark, he held them were visually similar. But when he considered the first Athlecia combination and the Athleta combination mark, he held they were only moderately similar visually, despite, they say, in the second case, both the mark and the sign each containing a similar roundel. That's where they put the case in paragraph 43 of their skeleton. And this is more so, they say, because the judge had previously found that adding a roundel would not create a significant difference between the marks. That's their skeleton at paragraph 44. We have addressed this at paragraphs 46 to 52 of our skeleton. The judge addressed this in totality between 114 and 117 of his judgment. We say there's no illogicality in the judgment, and I just want to walk you through the judgment with you to explain why that's the case. So starting at 114, the judge analyses the visual aspect of the respective roundels. Notes that one is a 9-bladed wind turbine or fan, as opposed to a geometric floored device, but held that the respective roundel devices would be considered undoubtedly similar to some degree. They're both round devices in a dark shade against a light background. At 115, he accepted the appellant's submission that the textual elements were visually similar to a high degree. 116, comparing the figurative marks, the textual element in both are similarly presented. 117, starting point, is he did not consider the addition of the roundel created a significant difference. The judge then finds the Athleta combination and the second Athlecia combination highly similar. Now you can see that self-evidently correct if you look over the page, or look back a page to paragraph 113 of the judgment, where you can see those, the mark, the relevant respective marks and signs at the bottom of each of those tables set out. But the judge doesn't give any reasons for that, he just makes a statement to that effect. The judge then finds that there are some obvious differences between the Athleta combination mark and the first Athlecia combination. And they're effectively they fall into two groups. Firstly, he says the roundel appears over the textual element rather than in front of the textual element. And he says, as I've held above, that is consistent with his earlier finding in relation to the Athleta purple pinwheel, that it's not a variant of the Athleta combination mark. Now, that's a reference to paragraph 71 of his judgment, so we need to go back to that. We pick that up. I mean, obviously, again, I take my Lord Justice Singh's comment in mind. The entirety of these paragraphs need to be read in their totality in order to understand what the judge is saying. But picking it up at the third sentence and reading through to the bottom of that paragraph, what the judge is doing here is holding that the different placement of the pinwheel, and again, just you can see the different, you can see it most visually very clearly on the previous page, at page 25 of the judgment, paragraph 68, you see the dark purple pinwheel placement above the Athleta word. So the different placement of the pinwheel, this is a difference which alters the distinctive character of the mark. While details of the roundel are not key, the roundel will not be ignored, point 1. Its placement will strike the reasonably circumspect consumer, point 2. Moving the pinwheel above will be noticed, 3. And finally, the conclusion is it was not the same mark as when the pinwheel is in front of the textual element. Now this is all in the context of the judge considering whether or not the sign is changing the distinctive character of the mark in question. I'm going to come back to that when I deal with their next ground of appeal. Now I go back then to judgment 117, so that's cross-reference is made in 117. He then goes on and says in the pre-penultimate sentence, the difference in the placement of the vandal will be appreciated, not considered a significant difference, but it will make some difference. Now that is a judgment that the judge is entitled to make. Indeed, it's a logical judgment. And the only logical conclusion from that judgment should be that the first Athlecia combination mark is less visually similar than the second Athlecia combination mark. And indeed, that is what the judge has found by holding that the first Athlecia combination mark to be of medium similarity as compared with the Athleta combination mark. Now, in simple terms, if a registered mark includes a word and a device, and the device is positioned in a specific location, it is logical that when it's compared with a sign containing that word and a similar device, which is located in a different position, that sign will be less visually similar than an equivalent sign in which the device is located in the same position as the registered mark. And that is all the judge is doing, and it's all he's found. It's impeccable logic, it's not internally inconsistent, it's not an illogical decision, no error of principle, rather it's logical and principle valuative judgment that the first instance judge was entitled to make. That's ground 4. Ground 5.
If something doesn't make a significant difference, what's that mean? Does it mean it's insignificant?
Well, there's a I mean, one can have a sort of metaphysical discussion about.
I don't want to be pedantic about
No.
it, but normally if you say it doesn't make a significant difference, that means that any difference is not significant.
Yeah, but that's not, and I understand that as a matter of pure logic, if that's pure logic, but that's clearly not what the judge had in mind when he was writing this, because it says make some difference. And therefore, reading this judgment fairly, as one has to do, rather than trying to find holes in it, he's saying there is a difference here, and that's a difference which is going to be noticed and appreciated, such that someone will think it's a different mark. That's what he comes to.
Sorry.
Yes.
The practical consequence of what he says is that it moves it from a high degree of similarity
To a moderate one.
to a moderate one,
Yeah.
which I totally accept that one has to read judgments fairly, but that sounds like quite a significant difference to me.
Well, it is a significant difference, ultimately, in the sense of how it plays out in terms of there being a likelihood of confusion. But it's a difference which he says will be noticed and has, it is some difference. Now, I appreciate, in the context, it could have been better drafted, but quite clearly what he had in mind is not saying it's negligible, saying the opposite of that. He's saying, admittedly he uses the word, it's not significant, but he then goes on and says, it is a difference which will be noticed and will be, and ultimately, the average consumer will consider that movement to change the distinctive character of the mark.
I'm sorry, please finish what you were saying.
Well, to change the distinctive character of the mark, and such that the average consumer will perceive marks of this type to be different from the mark as registered.
But what's the logic of holding that the placement of a device makes any alteration to the distinctive character and hence to the similarity? I mean, consumers are extremely well used to traders who use a combination of a word mark and a device mark. I mean, take Mercedes-Benz, any number of trademarks, and they're very used to the fact that the word and the device can appear in all kinds of different locations. The device may be above, it may be aside. What difference does it make to the distinctive character whether you put it to the left or above?
Because there's a question of fact in each case, Maud. There's no rule, it's a question of fact. Each case, the judge has got to evaluate in front of him or her what the sign is that's being registered. Now, the proprietor of a trademark selects the sign that he or she wants to be registered. They can say in terms, in their registration, I claim this word in combination with this logo, and it can appear in any location. They can say, you can use description text in that.
Yeah, well, judging by some judgments they gave recently, that would be invalid.
Well, it may be invalid. They may then register a whole load of individual ones separately. But what is different here is here you have, well, 2 points. One is you have them relying on Athleta as being the word mark alone. That's their one registration. Then they come along and say, doesn't matter, I've got a new mark. My new mark has a device in front of Athleta, and I'm having a monopoly in that specifically. They've chosen that, and the judge's job, ultimately, and I'll show you that he set up the right law when talking about variance, is to ask himself, what will the average consumer think about that in terms of whether or not if you move that device element, it's going to have an impact on the distinctive character of the mark. And the judge didn't say any movement will do. In fact, he says the opposite. He says he actually rejects that submission. I'm going to make this good in a moment. He rejects that submission specifically. Any movement is not good enough. And if it's just similar, and it holds specifically, it's obviously going to be similar in the front position. But his view is, for the average consumer in relation to this particular sign, this particular mark, when you move it above, it will make a difference. And it'll make a sufficient difference that the average consumer thinks it's a different mark. And that, as a matter of fact, he's entitled to come to. You may not like it, you may not have come to that decision, but it's an evaluative judgment that he was entitled to make. There's no rule of law that moving a figurative element with respect to a word element is permissible. It's a question of fact on each case.
Fact and degree, I think you would say.
Fact and degree. Yeah.
Which is where the judge saying at 117 that it has some, but not significant. That may be capturing what he was trying to say there.
Yes. I mean, I'm careful as to, because we're all slightly second guessing quite exactly what I mean on the spectrum.
Of course.
But it's quite clear on the spectrum what he was saying about this sort of movement is sufficient that it alters the distinctive character of the mark.
Yeah.
Now, he used the word significant. To be honest, in our speculations, that's a sideshow because his reasoning is quite clear. What he's saying is, when it's moved in that way, the average consumer perceives this to be a different mark, a different sign to the other one, and it has a different distinctive character.
How does that sit with what we've been told in the authorities about what the average consumer can be assumed to be like? They're not going to do this kind of close scrutiny, are they? And they will have an imperfect recollection. So how does it sit with that?
Well, again, I said actually feeds into that because all the cases what one sees where this has been looked at, you're effectively asking yourself, or the judge was effectively, or the tribunal was effectively asking themselves, they've seen the registered sign, and they think, what is the imperfect recollection of that? Feeding that into their minds, we're then looking at what the variant is, or what the change is. And in my submission here, that plays into us here, very clearly here, because the imperfect recollection here is that you've got a word and you've got a device closely associated at the front of it. That's the imperfect recollection. It's not two separate independent components. It's two things butted together. And when that's no longer in front, while you might not recall exactly what that thing was in front, you know it was in front, now we move to a different position. And that is a question of fact and degree that the judge was entitled to come to. As I said, a different court could come to a different decision, but this judge came to that decision on the facts before him, and he was entitled to do that.
Right. Now, I think you were about to move on to ground 5.
Yes. So that's, effectively that's what I'm feeding into right now, because that's effectively at this point, indeed. Because, yes, what my learned friends are saying in paragraph 47 of their skeleton in support of ground 5 is that the judge was in error in finding that the configurational change of two elements of a figurative mark was capable of changing, saying the judge was in error in finding that the configurational change of the two elements of figurative mark was capable of changing its distinctive character. what they assert in their grounds of appeal and in their skeleton, it's very careful one bears this in mind, is that there were independent elements and therefore they can be viewed separately and in isolation from each other. So they say that the ground, it says in terms, he urged his objection assessing the contribution of independent elements to the distinctive character of a figurative mark and its effect on likelihood of confusion and misrepresentation. But that begs the question as to how the average consumer perceives the registered sign in question. Indeed, we say as a premise it's incorrect, because for the reasons I was just seeking to explain. Prima facie, a registered mark for a figurative mark is staking out a monopoly where the sign to be perceived is perceived as a whole and is not to be broken down into constituent elements, even less that the constituent elements are to be viewed independently and in isolation from each other. And that goes right back to the Court of Justice in Lloyd's Shoe Fabric, paragraph 26, which was quoted by my Lord Justice Arnold, first instance in Walton, 120, quoting paragraph 45 of Budd, which the reason I'm going this tortuous route is it's in the judgment at 142. Sorry, judgment at paragraph 42. So the judge knew that the starting point is you must look at the average consumer must perceive the sign as a whole. And we say, therefore, on the contrary, component elements of the sign.
I'm sorry, I'm sure it's my fault, but I'm now lost.
Sorry.
So you've referred to the judge at paragraph 42,
Yes.
quoting Walton at 120.
Yes.
So this is all about variant form.
It is, but I'm starting from the first proposition, which is what effect, cutting through my learned friend's advocacy, ground 5 of his appeal is effectively saying, as a matter of principle, it's wrong for the judge to say moving a figurative element with respect to a word mark changes its distinctive character. And I'm peeling that back because ultimately what he's saying is no reasonable judge could come to this conclusion because moving a figurative element with respect to whether it's in front or whether it's on top is something as a matter of principle could never change the distinctive character of the mark. That's a cut to the heart is what he's really submitting. And what I'm saying is that begs the question as to what the average consumer perceives the registered sign to be in the first place. And it begs the question as to whether or not the average consumer perceives the sign to have a location element with respect to the figurative element with the word, or whether the average consumer does not. It's not a point of principle, it's a question of fact and degree for every single sign that you see. And I'm reinforcing that point by saying, as a matter of first principle, the average consumer perceives a mark
As a whole,
as a whole.
doesn't proceed to analyse its details.
Absolutely.
But your argument seems to be to the contrary.
Yeah.
Your argument is that even though the constituent elements of the mark are the same, if you spatially rearrange them, that somehow alters its distinctive character.
No.
Which seems to be
So,
contrary to
I'm being very poor in my explanation. What I'm seeking to suggest is that the average consumer perceives the mark as a whole without dissecting them up to think they are separate, independent component parts. So as a whole, the average consumer looking at this sign in question sees a totality which has a figurative element immediately placed in front of a word element. That's the mark as a whole. The average consumer does not then start to think, that's actually two marks, one of which is a figurative element, one of which is a word element, which are separate and independent, and therefore it doesn't matter that the figurative element can be geographically or spatially located in any location with respect to the word. That's contrary, as we say, to the starting point principle that the average consumer considers the mark as a whole without trying to dissect it in any way. That's my first proposition. And as a matter of fact, we say, the component elements of a sign and their respective positions will all contribute in one degree or another as to how the sign is perceived by the average consumer. Now, as I understand my learned friend submission, when you cut through it, what he's saying is that it's wrong as a matter of principle for the judge to find that the positional movement of the component elements of the figurative mark will never change its distinctive character. Now we can see this visually in Core Bundle tab 17, page 206. Where the registered mark and the variants are set out, page 206. The registered mark is at 3B, visually. And the appellant's proposition appears to be that as a matter of principle, moving the pinwheel element with respect to the textual element can never change the distinctive character of this sign. So, as a matter of logic, on the appellant's contention, putting the pinwheel at the end of the text of the Athleta word mark would mean it's not perceived by the average consumer as being different to the sign in which the pinwheel appears at the front. And we say just by stating that proposition shows the error in the appellant's case, because it always turns on a question of fact and degree as to how the figurative mark in question would be perceived by the average consumer, what the relevant figurative elements are, and how they're spatially located with respect to each other. That's an evaluative judgment which the trial judge must make on the specific facts of each case. And on the facts of this case, what this boils down to is whether the judge has erred in principle when considering that the average consumer will perceive the sign depicted at the bottom of page 206 as being different to that which is seen at 3B.
What do you say to the submission that Mr. Barron made that that's not the right test?
Well, I'm going to show you what test in a moment, such that its distinctive character has been altered. We say this is not a question of principle at all, but involves a question of judgment for the trial judge to ascertain whether the differences between the signs are such that the distinctive character has been altered as perceived by the average consumer, which is the right test. That's the law. That's what the law requires the court to analyse. It's what the judge set out as the correct law that he was being asked to do. And you can see that at paragraph 42 and 43 of the judgment. Variant use, where the judge sets out the law that he has to apply. So this is page 124 of the core bundle, paragraph 42 of the judgment. This sets out what the court is required to analyse. He sets out the correct law, paragraphs 42 and 43.
And what do you say about paragraph 122 of Walton that's quoted at the end of 42? As the case law, the General Court makes clear, alteration or omission of elements which are not distinctive is not capable of altering the distinctive character of a trademark. So pausing there,
Yes.
your submission was that if there's a difference, that is sufficient. How is that consistent?
Well, because the judge has already found that the roundel is distinctive. That's in the judgment of paragraph 32. So he's found both the word mark and the are distinctive. And what you've then got to look at as a matter of fact is whether or not...
Sorry, which paragraph is that? I'm so sorry.
Sorry, paragraph 32, my lord. 32, I'll go back to... you'll see, this is where the judge is holding that...
Yes, well, you're absolutely right to point that out, and I'm grateful. But where does he say that the positioning of the roundel is crucial to its distinctiveness?
Well, I'm going to show you that, my lord. I'm going to show that when he's doing his reasoning as to why he says it is different. So the law is no challenge to them setting out the right law. He sets it out there at 42 and 43. And then he applies the law to the facts of the case, and that starts at paragraph 69. And he first of all addresses the submission, which is the board submission, which I think maybe my lord has in mind, which was rejected by the judge, made by my clients at first instance. 69, our clients submitted that the extent of the Athleta combination mark is, to the extent that it's not entirely descriptive, it has a very low degree of distinctiveness, such that the changes to the pinwheel element, including adding a circular background and or moving it, will change the distinctive character of the mark. That he rejects.
So moving the pinwheel doesn't change the distinctive character.
My lord, you have to read the entirety of the judgment, okay? Entirety of the judgment. He's saying that the submission was that any movement and any change would not change the distinctive character of the mark. He rejects that. And then in 70, he addresses the use of the dark pinwheel and the Athleta confirmation mark. And he applies, and in 71, he applies it in relation to the purple pinwheel. And what he does in both cases, he applies the law correctly in both instances. Firstly, identifies the differences. Then secondly, he asks himself, do the differences alter the distinctive character of the mark as registered through the eyes of the average consumer, viewing the mark as a whole, by analysing the oral, conceptual and visual qualities of the respective signs. And in relation to the first variant, which he addresses in paragraph 70, he considers as a valid judgment, giving his reasons, that it will not alter the distinctive character of the registered mark. But in the case of the second, the different placement of the pinwheel does alter the distinctive character in his view, because he considered that whilst the details of the roundel may not matter, its placement will, so far as the average consumer is concerned, because the placement will not be ignored, it will be noticed, it will be perceived as being a different mark. Now that was something which he was entitled to, always, first of all as a matter of law he was required to do, and as a matter of valid judgment he then applied and did, and came to that conclusion. And again, different judges reasonably come to different conclusions, but this is one which he was entitled to come to. The only reason he could not come to that is if there were some point of principle that by merely moving figurative element alone, with respect to a figurative and word mark, could not change the distinctive character of the mark. We say there is no such principle of law. Now, we say, backed up in my learned friend's very clever submissions, therefore, a number of errors which have encouraged, I've been seeking to encourage this court to follow, which would lead this court into error. The first is to assert that the average consumer will consider the registered sign to comprise two discrete and independent signs, namely a pinwheel and a textual element, and that the respective location of those two elements would not be considered material to the registered sign. That's the way in which he's crafted his grounds. It's not one based on the facts, and not one which the judge was attracted to. It is, in fact, salami slicing the registered mark, which is precisely what the judge is told the average consumer is very unlikely to do. That's paragraph 47 of my learned friend's written submissions. Paragraph 48, they seek to encourage, as they did orally before you, that there's some point of principle. And they seek to turn the specific facts of two particular general court cases into a general principle of universal application, namely to assert that because elements of certain figurative marks may be perceived as being independent of each other, their positional rearrangement will never amount to changing the distinctive character of the registered mark. There is no such general principle of law. Each case will turn on its own facts. They took you to two cases, GFK and OM. I'm going to do this very briefly, but the point in relation to this, that both of these are on their own facts, but specifically, if I could take you to GFK first, that's in the Authorities Bundle 2 at tab 4, page 171, I'll pick it up if I can, where you were showing this by my learned friend, so I hope I can do this pretty briefly. This is the German registered mark is at paragraph 5. For business consultancy, and paragraph 6 is the use of the mark relied on. And the question was that variant use or use of a different mark? And paragraph 9, the Board of Appeal held that the figurative element is made up of interlaced triangles and the word bus were the two distinctive elements of the earlier trademark. That's what they found. And paragraph 19, the applicant contended that the distinctive elements of the sign used differed from the registered trademark for 3 reasons. And those 3 reasons are set out in paragraph 20, firstly, that it doesn't use the descriptive words. Paragraph 21, because the bus is written in black under the figurative element of the interlaced triangles, when the sign has used its white and on black triangles and placed it to the left of the symbol. A number of elements there. And thirdly, paragraph 22, that the colour of the interlaced triangles are different and used, sign has an extra black square. Then we have Owen's contentions, and you'll see that they contended the removal of the text was insignificant and merely a descriptive reference. They that is, see at 24 and 25, the representation of the word bus and the figurative element in the negative is acceptable as a current variation. Doesn't affect the form as registered. Black square addition is insignificant. And at 26, you say you must have a margin of flexibility. The findings of the court key ones start at 34, and again, my learned friend's taking you through these. 34 include both bus and figurative element, which are distinctive. 35, different presentation, namely the typography and the colours, neither original nor unusual in either form. That doesn't affect the distinctive character. 36 to 39 deal with text and say it's not material. 40, I say black square is not material. And 41, the differences don't alter the distinctive character. So this decision, in fact, does not directly address and engage with the issue about the change of position of the figurative element vis-a-vis the word bus. It's implicit, obviously, it considered that it was immaterial on those facts, but there's no reasoning, and it's not expressly addressed. So it's not good authority for the appellant's proposition that as a matter of principle, that moving a figurative element vis-a-vis a textual element will always have no impact on the distinctive nature or character of the registered mark.
I noticed the last sentence in paragraph 41,
Yes,
which seems to be the eventual conclusion
yes,
of the court.
Exactly.
Have I understood that correct?
that's right.
It's not even saying that's the court's view.
No, exactly. And that's exactly the same point I'm going to make in relation to the next one. The trouble with these general court cases is that mostly they're saying, was there an error committed below? Not, here's the point of principle. And so here they're saying they're fully entitled to come to their conclusion. And that's it. That's all you've got.
Yeah, but they're not looking at it in the same way that we do in this
No.
jurisdiction, because the Court of Justice, the General Court, has jurisdiction over the facts, by contrast with the Court of Justice.
And the simple point in relation to the next case, well, the three points in relation to this case, obviously not binding, doesn't set out any principle, and on the facts of the case, actually that there's no analysis at all as to why the lower courts found that the positional change not to give rise to a change in the distinctive character of the mark in question. And I can show you that again very briefly, if I may. Tab 5, seen the marks. What I'll go straight to, if I may, is paragraph 10, if I can. This is the cancellation division, held that the use with the device on the left-hand side, smart thing, was genuine use of the mark as registered, but no reasoning is given. You'll see that, paragraph 10. And so we're not given any explanation as to why that was conceived not to have changed the distinctive character of the mark in this case. And similarly, in relation to paragraph 14, you get the Board of Appeal, no reasoning given there either. And jumping right to the conclusion at 90, picking up my Lord Justice Singh's comment, is that the ratio, again, is 90. The Board of Appeal was right in finding the distinctive character of the mark could not be regarded as having altered in the ground figure element mark situated left and right mark backing. So
That does seem to be going further.
well,
They're saying
possibly,
right.
possibly on that one. But the actual, sorry, I apologise. 92 is the ratio. The Board of Appeal did not err in finding the genuine use of the mark.
Yeah, but there's two different questions in play here. First is variant form, as to which in both cases the General Court explicitly makes its own finding.
Yes.
Then there's the consequential decision as to whether there's genuine use, as to which, because it's held that what was done below was right on variant form,
Yes.
therefore there's no error when it comes to genuine use.
My Lord is quite right, and I apologise that I've been sandwiching together. The point I'm trying to make is neither of these cases is addressing what my learned friend seeks to address from it, which is that the variant use, as a matter of principle, there can be variant use, or put it the other way around. It doesn't change the distinctive character of the mark if there's a geographical or spatial movement of the device compared with the word mark. They're all on their own facts, and there's no reasoning given about it.
Yeah. So to summarise, your submission is that in paragraph 90 in LG, you say that's not a statement of principle; it's purely an assessment on the facts of that case.
Yes, it is. And I apologise, Mould, if I did that too speedily. Yes.
Now, Mr. Van Hagen, I don't want to rush you,
No.
but you've got two other grounds
I have.
to address.
And
we've
I
got
believe
about
I'm allowed to about 22, so I think I've got about half an hour.
Yep.
But I'm going to get there. I'm going to get there.
No, that's fine. It's up to you how you present your submission.
No,
I just wanted to remind you.
I'm very grateful because I haven't got a watch on, but I have been looking. I think I'm in time, my Lord. So let me just check if there's anything else on this ground before I deal with the other two. Yes, I should just pick up a number, two or three other points just on this ground alone. Pick up paragraph 50 of my learned friend's skeleton argument. At heart, this is a direct challenge to the judge's finding that the change of position of the roundel to above the Athleta word mark would be noted by the average consumer and perceived as a different mark. And at its heart, this is actually a submission by the appellant that no reasonable tribunal could have come to the conclusion the judge did in paragraph 71 of his judgment, i.e. this is an irrational decision. And we say that argument's not open to appellant, not in their grounds of appeal, nor is it open to this court. In any event, the decision is reasoned and rational. Paragraph 50, they relied on the easy group case, but they didn't rely on it orally. We've addressed it in paragraph 59 of our skeleton. I'm not sure I need to take you any further in relation to that. The facts of that were very different again. And that was all a question about whether or not you would perceive the variant as being two discrete signs as opposed to a single sign. And I've just asked, in terms of ground 5 as to whether it's entirely academic, we've also made a few comments in paragraph 60 of our skeleton, which we stand by. So, and finally on this, my learned friend, generally in relation to trademarks, said you should have some comfort from the German judgment. Well, he's quite right not to place any weight on that at all. It's not binding. It's taken on its own facts and its own decision. You shouldn't take the false limb of support that offers any comfort. You've got to apply the law to the facts currently found. Passing off then, ground 6. The ground is that the judge allegedly erred by dismissing the contribution of the variant forms in establishing goodwill. It's the ground. Again, we've addressed this fully in paragraph 65 to 79 of our written skeleton. But may I start by going to the judgment at 167, please. So what the judge does here, he identifies the 4 signs in respect to which Athleta claims to own goodwill in the United Kingdom. Now, that is the case that was pleaded before him. That's what he was asked to do. And can you please take the core bundle and turn to tab 17 again, please, and turn to page 206. Again, the pleaded case. Paragraph 5 is that they were relying on the 4 signs, those two set out at 3A and 3B, and the signs set out at 51 and 52 below. There's a case of 4 discrete signs, each of which had generated goodwill, and that was confirmed by the way in which the parties asked the judge to address the issues before him in the list of issues, which you can see in the judgment at paragraph 11. And he cites the judge sets out the list of issues at paragraph 11, sub 4, passing off. As of the 30th of November 2021, did Athlecia own protectable goodwill under each of the Athleta signs? And the Athleta signs were defined in this judgment at paragraph 5 as being the 4 signs that are set out in paragraph 5 in the previous couple of pages. There was no pleaded issue that each or any of the signs in which goodwill was said to have been generated had been used in a variant form so as to enhance its own goodwill. Now, going back then to the substantive parts of the judgment, at paragraphs 171 to 178, the judge sets out the law, and his assessment begins at 179. At 185, the judge turns to goodwill and notes the different relevant date compared with assessing date for genuine use, i.e. 30th of November 2021. The judge then found there was goodwill in the word mark as applied to clothing, that's 186, but not enough evidence to establish goodwill in the word mark as applied to bags. That's 187, and is not appealed. The judge then, at 188, applying the same principles and having regard to the evidence before him, considered whether there was any goodwill in the Athleta combination mark. Similarly, at 189, he addressed the Athleta dark pinwheel. And finally, at 190, he addressed the Athleta purple pinwheel. In each case, the judge held there was no protectable goodwill in relation to each of those signs. Now, there is no discrete appeal on judgment 188, i.e. there's no goodwill in the Athleta combination mark, or in 190, no goodwill in the Athleta purple pinwheel sign. As to judgment 189, the Athleta dark pinwheel sign, there is an appeal against an alleged omission by failing to take into account some material facts. It's hopeless. The judge clearly had the facts in mind, but I'm going to address you with those after I've dealt with this ground 6. We've addressed that in our skeleton in terms of...
Sorry, you said that the finding in 190 wasn't challenged, but that's ground 7. Judge,
no, it's 189.
By failing to properly consider the evidence in relation to the Athleta dark pinwheel. I appreciate you haven't got to ground 7 yet.
No, it's 189.
But I'm just trying to understand your submission that there's no challenge.
No, so there's no challenge to 188, nor no challenge to 190. There is a challenge to 189. That's the one my lord has got right, the dark pinwheel. That's 189, not 190. That's what I was addressing.
Yes, I'm sorry, I was getting the two mixed up. Thank you for correcting.
It's horrendous. Sometimes coming this cold. I do it all the time, but it's 189, which is ground 7, my lord. So we're speaking from the same.
Yeah. Okay.
Same basis. We say that's hopeless. We say it's based on an omission. Now we say, given those findings in 188, 189 and 190, on the assumption, of course, I'm right about 189, what variant use is it suggested that the judge should additionally have taken into account for each of these marks? And how would it have made any material difference given his findings in the judgment at 188, 190? So, since 188 addresses the Athleta combination mark, the judge finds the mark has not really been used significantly in the UK in relation to clothing or bags to establish goodwill, causing there, it's fully entitled therefore to find no goodwill in the combination mark. However, he goes on and comments there is some use in relation to the Athleta dark pinwheel, in contrast to the insignificant use of the Athleta combination mark, which is already held to be so insignificant that no goodwill arises. Now, the judge in the final sentence of 188 is alluding to the judgment at paragraph 70, where he found that the Athleta dark pinwheel was a variant of the Athleta combination mark for the purpose of considering genuine use of the Athleta combination mark. But for passing off, he was not being asked to consider whether the use of the dark pinwheel contributed to the generation of goodwill in the Athleta combination mark. He was being asked to address each of the 4 Athleta signs individually and discreetly. So unless the Athleta combination mark had itself been used, no goodwill could be generated in it. Now, there's nothing wrong with that, given the way that the appellant had pleaded and presented its case for passing off. And as my lords, I'm sure, are aware that in a passing off case, the pleading is the essential starting point for defining the sign in which goodwill is said to reside. Because unlike in a registered trademark infringement case, where the sign is registered, it's open to a claimant in a passing off case to rely on any indicia or any parts of signs or any parts of marks or combinations which they may assert have become distinctive of them. But the pleading must precisely define those signs so that everyone knows the sign in respect to which the claimant claims goodwill.
So can I just be clear?
Yes.
Whether you're making 1 point or 2 here? I mean, I totally understand your point that the pleading is important and it defines the sign for which protection is sought, or in this case, the 4 discrete signs. I understand that point. But are you making a separate point that even if it had been pleaded, which you say it wasn't, as a matter of principle, in a passing off case, you can't rely upon an argument of variant forms?
I'm not sure I need, well, I'm not saying I only need to go that far, but as a matter of principle, the question, what you're trying to define. So if by variant forms you mean I rely on sign X as being my distinctive sign, it is used in a variety of different ways, but the distinctive element that I'm relying on is X. That is a perfectly good pleading. And you may be, and using the language of my lord, it may be you're saying, when I'm using sign X, it is being used in a whole variety of different ways. And
so you would accept in principle?
In principle,
you could do that.
Of course you could. If that's what my lord means by variant use, yes. And that is, as we all know, that is, my lord used Mercedes-Benz. I mean, that is, we know that Mercedes-Benz is used in a variety of different ways on vehicles, in purely word marks, sometimes in the 3-pronged star and so forth. And each of those you could rely on as being used in Mercedes-Benz. The flip side doesn't necessarily apply though. So the fact that you're using Mercedes-Benz and your 3-pronged star doesn't mean you're using 3-pronged star when you're only using the word mark Mercedes-Benz. So one has to be careful about what one's defining as being the sign you're relying on. And here, they've relied on 4 specific signs and said, that's what we're saying is distinctive of us. Now, what the judge did then was address what he was asked to address in the judgment, and on the facts in respect of each of the specific signs relied on, he came to his evaluative conclusion. and that we say is the ultimate, the end of the ground 6 appeal. But even if there was some sort of argument, entirely against myself, that there was some pleaded case that the Athleta dark pinwheel contributed to the goodwill in the Athleta combination mark, the judgment at paragraph 189, given that he's found that the Athleta dark pinwheel didn't establish any goodwill, it would have made no difference if the judge had, notional or otherwise.
But that's subject
That's
obviously to
ground
ground
7.
7. I mean, this is why
Absolutely.
Mr. Brand accepts he has to prevail on ground 7 as well.
Exactly. And it's only on ground 7. So I just want to nail it completely down. So that's the only variant he could possibly be relying on. He can't be relying on the Athleta purple pinwheel, because that's even more irrelevant. Firstly, because the judge has already found it to be a different mark and sign. And secondly, because paragraph 190 is not challenged, and the evidence of the use of the purple pinwheel was inadequate to generate any goodwill. So what we are left with then is, even if, this is the point I think my Lord Justice Arnold put to my learned friend near the closing of his submissions, even if ground 7 is successful, ground 6 adds nothing to it, because the premise must be that this court should have found that there was some protectable goodwill in the dark pinwheel sign. If that's the case, what on earth does ground 6 add to that? Because if ground 7 is successful, the appellant will have established goodwill in the dark pinwheel sign and not in the combination, and will be entitled to relief where there is a misrepresentation in respect of any sign, which would be understood as confusingly similar to the dark pinwheel sign. The appellant would not, however, and should not be given any wider form of protection in respect to a different sign, which has never been used by it at all, i.e. pure combination sign. That's my submission on ground 6. Ground 7. Again, we've addressed this in paragraphs 80 to 83 of our skeleton. Generally, in relation to their skeleton argument, paragraphs 67 to 74, we agree a small amount of trade may be sufficient to generate actionable goodwill. It's all a question of fact in each case. We do quibble at their paragraph 72, where they say looking at other cases as a guide. We say it's not helpful when the facts may be materially different. But the key principles on this were common ground between the parties before the judge, and as my Lord Justice Miles quite rightly pointed out, the judge set them all out at paragraphs 172 to 175, and none of that's challenged by the appellant, nor could they seek to do so as it's common ground before the judge by the parties. Now, at their skeleton at paragraph 75, they say the judge was wrong in failing to find goodwill in relation to the Athleta dark pinwheel because of the John Lewis use in store, on website, on clothing and on swing tags. And the suggestion in paragraph 76 of their skeleton argument is the judge was wrong because he did not take specific evidence into account. Thus, the appellants infer, because he failed to give reasons for dismissing the evidence, they rely on as set out in paragraph 76 of their skeleton. Now, the answer is effectively 3 or 4 points. Firstly, the judge took the John Lewis use into account. That's clear from judgment 180. And see the last sentence in particular. The photographs of the John Lewis store clearly show clothing being sold under various of the Athleta signs. Secondly, the date of assessing goodwill is the 30th of November 2021. Again, the judge makes that quite clear at his judgment at paragraph 170. This is a different date from assessing genuine use of the trademarks, and the judge clearly had this in mind, as he reminds himself at 185 of his judgment. So, as a starting point, the appellant's skeleton argument, paragraph 75, lists many examples of purported use, which they say the judge should have taken into account to establish goodwill, all of which took place after the 30th of November 2021. And obviously, the examples, yes, many of which are, well, and we've set them out in our schedule as to which ones are not correct. And it would have been wrong for the judge to have taken all of those into account. There are others, obviously, which are within the relevant period, which we're going to address in a moment. Thirdly, several of the so-called John Lewis examples set out in their skeleton at paragraph 75 simply don't show the Athleta dark pinwheel at all. And again, we're set out in Schedule 2 of our submissions where that's the case. Now, the totality of the evidence before the court relied on by the appellant to seek to establish goodwill in the Athleta dark pinwheel up until we had tried to trawl through everything we could find, and we had set that out in Schedule 2 of our skeleton argument. My learned friend then, for the first time, at about 12:30 this morning, identifies in his handout SB1, which it repeats all the ones we've already identified in relation to the John Lewis stores, and then a collection of the International Athleta website. I can dismiss the international one straight away, my lord, for the same reasons I've dealt with it in the non-use or revocation basis. These, as I said, have been raised for the very first time. They're not in skeleton, but raised for the first time orally. But they all relate to the US website, in respect to which there was no evidence of how many people visited or how many page visits were to any of those particular pages before the court. So our Schedule 2 to our skeleton was the totality of the evidence before the court relied on by the appellant to seek to establish goodwill in the Athleta dark pinwheel, that they could do so. Footnote 55 points out those which are irrelevant. So the only relevant material for the judge was in relation to John Lewis, set out in A and B in our Schedule 2. A is a single website image from the 19th of January 2021. And B is 16 photographs of an in-store use in a 3-week period in September 2020, 4 of which show a swing tag. And there is no evidence before the court as to how long these remained in store in this form. No evidence as to how many potential customers could possibly have seen them. Indeed, none of the photos show any customer or human being at all. No evidence that any single product was sold bearing a swing tag with the Athleta dark pinwheel. Now, my lords may have to recollect, because I forgot, my learned junior quite rightly pointed out to me, these are all from a 3-week period in September 2020. You may recall, on the 14th of September 2020, the rule of 6 gathering was imposed. On the 22nd of September, return to working from home was imposed, and by the end of October, the second lockdown was announced. So this isn't just simply, again, another Van Heegen technical point. This is them, again, needing to prove evidence of use to establish goodwill. And they have just failed to do it. This is the totality of the evidence relying on them to seek to establish evidence to goodwill in England and Wales for the dark pinwheel sign for clothing and for bags. And we say, in light of that material, the judge was entitled, at paragraph 189 of his judgment, to find that even taken at its absolute highest, there was insufficient evidence to establish goodwill in relation to clothing or bags for this mark. That was an evaluative judgment, which a judge was entitled to come to on the materials before him. It wasn't an irrational or logical decision, neither of which, of course, is the basis for the appellant's appeal. On the contrary, the appellant's appeal is suggesting that the judge should not take this material into account, i.e. there was a material omission. Well, that's the one thing he's going to be sure he did take into account, because the John Lewis thing he expressly refers to in the paragraph of the judgment I've just shown you. So, to look at that material at its absolute highest, we say he was entitled to say that that was not sufficient to establish a goodwill and reputation in this mark in relation to those goods. And that was an evaluative judgment he was entitled to make. Unless I insist you further, my lords, there's our submissions.
Check if my lords have any more questions. No.
I'm very grateful, thank you. And I apologise for just being a little bit.
No, that's fine, thank you very much.
I will commence with reply points on ground 1, and then I'll pass over to Dr. Barron for the other grounds.
Yes.
As a first point, may I direct your lordships to the judgment at paragraph 104. So that's in the core bundle 139, bundle page 139.
Yes.
My learned friend went to this paragraph and suggested that this was the end of the matter for ground 1. Just highlighting the last sentence there was the judge saying I should have a complete list, that my conclusions would have been the same had I included all of Athleta's variants as use of its marks and or included Athleta's US facing websites as use of its marks. That does not solve the problem that we say it has of considering genuine use being dependent on the scale of use. That's still an issue even here where he says he would have found the same conclusion. It's because he's got that error as well. We've got two aspects to ground 1, and that's the reason for that. Moving on, my learned friend spoke about advertising as well at length. What we have on the Athleta website is not advertising. It is the offering to expose goods for sale, put them on the market, or stock them under the sign. That's what we're relying on. So these references to advertising, different requirements in relation to advertising, we say is irrelevant to this case. There's also been several submissions about the visitor numbers to the website. Just to be clear, there are visitor numbers to the website in the case. For your lordship's reference, that is at the second supplementary bundle, tab 10. And those visitor numbers were acknowledged in the judgment at paragraph 55. So there are visitor numbers to the website in general. And also there was reference to why haven't we included images about from the website. There was the drop-down menu which said bags and headgear. And there was the suggestion that we should have included those sections of the website in evidence. This is a limitation of the Wayback Machine as to what it mines. It doesn't necessarily mine everything. That's a reason why those items are not in evidence. There was some discussion in the supplementary bundle, the second supplementary bundle at page 90. If you recall, that's the website with the images of the various headgear and bags that we were directed to. There was discussion about whether they were Athleta branded items or third-party branded items. You can see, if you look in that section, that there is a reference to Power Vita. It's one of the names of the headgear that is there. That is an Athleta brand. And you can see that by following through the logic of the John Lewis invoices, which I gave the references earlier, at Supplementary Bundle 1, pages 146 to 148, they all refer to this Power Vita. Also,
You mean sub-brand?
Sub-brand, yes, indeed. And also the purchase by Stevenson Harwood, the invoice for that at Supplementary Bundle 2, page 184, references to the same sub-brand. And then on the page 186 of that same bundle, you can see that it has the Athleta combination mark on it, so that completes the circle there of this is a brand of Athleta. They are the ones that are offered on that page.
That's one example, though, but there was that one with the upside down V.
Unfortunately, I cannot assist you on that one, but
And the sock.
I cannot assist you on the sock either. The sock is irrelevant for the goods that we're interested in anyway. We're headgear and bags is the goods we're interested in relation to the revocation, rather than footwear. We've no longer.
But it's partly a matter of what one can make of the evidence.
Indeed. But so in relation to other products on that page, there are tote bags as well, which have the slogan "Power of She" on them. That is a slogan of Athleta. I can make that good by looking at Supplementary Bundle 1, bundle page 198 at paragraph 8. That's the witness statement there, which says, in quotes, "Power of She" as relation to the Athleta brand as well. So from those submissions, you can see that numerous of those on that page are Athleta products. So unless I can assist any further on ground 1, I will pass over to Dr. Barron.
Thank you.
grateful. Just a few points on each of the grounds, and I'll take them as quickly as I can. First, ground 3. My learned friend went back to things that had been said below, as if producing some sort of prize to show that I'd accepted there that the mark was elusive. I've always accepted that. I said it this morning, and I continue to accept that the mark has an elusive element. That's never not been part of my case. The point is that the elusive element that the judge was considering, Athlecia, is not the whole of the mark, nor is it the only point of similarity. You have no answer from my learned friend to the fact that paragraph 159 of the judge's judgment still relies on a finding that is flat wrong, when he says the only point of similarity is the common element Athlecia. That's flat wrong as a matter of reading the mark for yourselves, my lord, but it's flat wrong on the basis of the judge's own findings at, I think, 115, where he's considering the visual similarity. My learned friend relied as one element of the difference, the length of words being different and their suffixes are different. Well, they've got the same ending, as I said, the same letter at the end, which is, in a short mark, a relevant feature, and the judge expressly found at paragraph 115 that the different length of the words will be difficult for average consumers to perceive. So that's not a relevant point of similarity, and my learned friend was wrong to rely on that too. My Lord Justice Arnold asked my learned friend, how could it be more similar than...
My Lord Justice Singh gave an example.
He gave an example, yeah, but as my Lord knows, this is a question, these are qualitative assessments. It's pretty difficult to see that there would be many examples that would be more similar than something that's found to be highly visually similar, highly aurally similar, and highly conceptually similar. The gap between that and a requirement for identity is exceptionally narrow if it exists at all. And as my Lord Justice Arnold rightly said and put to my learned friend earlier on, the law is clear that where a mark is registrable, it must be enforceable through the provisions that the Act gives. There's no point allowing people to register marks they can't, in some circumstances, enforce. And so it's not good enough to offer only identity infringement for a species
Well, that's a
registrable
proposition
mark.
that seems to prove too much, because nobody's saying this mark isn't enforceable, because it could be enforced against a double identity scenario. But your proposition, I think, is more that if it's registrable, it must be enforceable under section
Yes, it must be
subsection 2.
enforceable in the ways that are provided for. Yeah, absolutely, 1 and 2. Yeah, it's not enough to offer identity infringement alone.
Yeah.
That's the principle.
Can I just ask you about your submission on 159? I was just looking at it again. Does the judge actually say it's the only
He does. Well,
common
yes, he does.
feature?
So,
That was your submission, and I'm just wondering whether that's fair, actually.
well, the second sentence says, in the words of Arnold LJ in Lifestyle Equities, if the only similarity
Yeah.
between the trademark and the sign is a common element, blah, 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 the common element may have low distinctiveness because it's descriptive or elusive. In my judgment, that's the case here. The common element between Athleta
So you
and
say we
Athlecia
should
is
read
Athlecia.
that as only?
Because of the
When it
sentence that follows, yeah, absolutely. Because he says the common element. So there are two respects in which it's clear that's what he means. First, because the quote says the only similarity between, and he says that's the case here. And second, because he goes on after saying that is the case here, to say the common element between Athlecia and Athlecia is Athlecia. That's not right. One of the common elements is that one. The other is the A, the terminal A, and possibly another one is the length of the marks that he's found to be materially the
I
same.
don't want to get into wordplay, but actually the sentence that I think he's agreeing with is the next sentence of my Lord Justice Arnold's quote, where he says the common element may have low distinctiveness because it's descriptive or elusive.
I can understand that, my lord, and that might work if it weren't for the following sentence of the judgment, where he says the common element is Athlecia. That is false. It's one of them. So if I didn't have that following sentence, I could understand. We could say, well, he could have meant one, he could have meant the other. With that following sentence, I'm afraid I can't agree, my lord, that that is what the judge meant. He's absolutely clear with that following sentence. The common element between those marks is Athlecia. That is not correct. And this principle only applies.
And the other common element is the use of the A at the end.
The use of the A at the end, and possibly, as I say, the length, whether we treat that as a separate element, is a separate factor.
That's not the same.
But the judge has found that they're not materially different. That's in paragraph 115, because he says that the difference between the lengths would be difficult to perceive in use to the average consumer. So if it's imperceptible to the average consumer, then for present purposes it is the same.
Right. Thank you.
So I'm afraid, reading 1159, that is the only sensible way to understand what the judge was saying, and it's just not right.
Thank you.
Next you were taken to the evidence of Miss Gwilym that Athleta was an athleisure brand. My learned friend said that showed or gave evidence that it was elusive. I don't accept that at all. I accept that it has an elusive element, I've already said that, but there's no description, nothing in the evidence that says it's elusive or explains that it was meant to allude to or anything like that. The evidence just tells you that it's a brand that's used in relation to athleisure, which is certainly true. So that evidence can't assist you at all. Nor can the case of office cleaning, which is about the wrong tort in the wrong century and the wrong type of mark, because it's about descriptive marks, which are not at issue here, as the judge rightly found. So those are all my reply points on ground 3. Ground 4. My learned friend sought to place some reliance on some text in the middle of paragraph 114. I'm sure he just misspoke. The text he pointed you to is in fact part of a submission that was made by SGD that the judge then rejected. He says, whilst this further point is undoubtedly true, in my judgment it involves a level of deception that would be...
the paragraph again.
Sorry, 114, my lord, which is on page 141.
Yep.
My learned friend took you to some findings in the middle of the paragraph about the difference being enhanced by the lack of reflective symmetry and so on, but the judge rejected that in the next sentence and says later on, I'm unconvinced the level of analysis proffered by SGD's counsel. I don't think it's a big point in my learned friend's case, but I wanted to be accurate about it. That's not a finding of the judge. Next, significant degree again. Right, so paragraph 117 of the judgment. My learned friend said that the judge correctly said, the judge says he doesn't consider that the change in placement of the roundel will make a significant difference, but it will make some. My learned friend said the logical conclusion must be that the first Athlecia combination is less similar than the second Athlecia combination. But if we take all of this sentence, what it actually must mean is that the first Athlecia combination is less similar than the second Athlecia combination to an insignificant degree. Because that's what he said, some difference, but it's an insignificant one. Can't cherry pick part of the finding. Fundamentally, the inconsistency here, as I've said in opening, lies in the fact that the judge, it's the point that my Lord Justice Miles put to my learned friend. The judge says that this change is not significant, but then finds that it's the only factor that changes the similarity from high to medium and therefore takes you out of infringement. It's pretty significant to my client because that factor and that factor alone deprived it of a finding of trademark infringement. A factor which the judge had simultaneously found, through the eyes of the correct person, was insignificant. It can't be insignificant and dispositive at the same time. That's the inconsistency, and you've heard no answer to that whatsoever from my learned friend. So that's ground 4. Ground 5 next. My learned friend at one point, and my Lord Justice Arnold put it back to him this way as well, so I'm glad that I had understood my learned friend's submission the same way. He said that a movement that was perceived as different would be enough for a change of distinctive character. That's just another version of the noticeability test, and it just can't be right on the law that I've shown you about the purpose of the variant use provisions, including particularly that paragraph 89 in LG Electronics, which explains why we have the variant use provisions. If no perceptible difference is allowed, to a trademark lawyer, no perceptible difference means identity. That effectively means no variance. And that's exactly the point that LG Electronics makes. The General Court says, if you start looking at tiny tweaks like this, then you defeat the whole purpose behind this sort of provision. This is exactly the sort of thing, for the reasons my Lord Justice Arnold put to my learned friend, that everybody's used to seeing composite marks being presented in slightly different configurations. And there might be very good reasons in the real world why a company might need to reconfigure their mark to fit it on, and I gave you some examples earlier, whether it's an avatar for social media or a mobile compatible version of their web page, or a particular clothing label so it can't be extremely wide or something like that. They've got to be able to reconfigure their mark in that way. And LG Electronics makes clear that that is something that emerges from the principle behind variant use. It's not just an assessment of fact. It's got to be one that comports with that principle and that effect of that law. GFK, the GFK case, similarly, that's the pre-Brexit one. My learned friend took you past paragraph 26, which explains that there must be a margin of flexibility. And that's stated also as a proposition of law. There has to be a margin of flexibility for those to accommodate those real-world necessities of reconfiguring your mark. I'm just going to take a moment to try and work out what my next note means. Oh yes, my Lord Justice Arnold asked my learned friend about paragraph 122 of Walton, which is quoted underneath 42 of the judgment in this case. And he said, if it's your test of just any perceptible difference is enough to change the distinctive character, how can this last sentence be right, which says that one of the elements can be removed without altering the distinctive character? And you didn't get a satisfactory answer. The answer lies in that principle from GFK and from LG Electronics. There has to be a margin of flexibility so that some things which may be noticeable can be done without altering the distinctive character.
But isn't it all a question of fact and degree?
It involves a question of fact, but it's not only a question of fact, no, because it comes from that legal principle. We've got to ask ourselves, am I, in this determination, giving proper effect to these provisions and their purpose? And that's what LG Electronics says. It says from the case law and from those provisions. You remember paragraph 89 that I showed you, says expressly, out of the case law. That's the answer. My learned friend also told you that I think we got there in the end, but under the Rules of Procedure of the General Court and Article 72 of the EU Trademarks Regulation, the General Court does reach its own view in addition. So where it makes a statement about the alteration or not, in both of these cases, not of distinctive character, that is it saying not only that that was available, that it's right, but it says that the reason it's right is because of the principle of law. And that's in GFK, where it states at paragraph 26 about the margin of flexibility from the law, it says expressly, and paragraph 89 in LG Electronics, which says, because of the law, this is the way we must approach it.
Was LG Electronics about genuine use?
Yes, it was an opposition case. If this is the one that I took you through in more detail than the other.
No, I'm just trying to remember which.
So it's an opposition
the other case was about
and the opponent relied on an earlier mark.
Yeah.
They both have this shape, actually. They are opposition cases. The opponent relied on an earlier mark.
Yeah.
The registrant or applicant is then entitled to say, well, if you want to rely on that earlier mark, you better prove you've used it, because if not, it gets revoked down, so you can't use it as a weapon against me. Proof of use was then requested, and the question was, in both of those cases, was there use evidenced by the use of the variants that appeared in the evidence?
Right, so that leads to the question I wanted to ask you, which is there possibly a difference here between the principles which concern genuine use and distinctiveness in that context, where it's been held, as I understand it, that even low distinctiveness is enough.
Any distinctiveness is the law. There's a case called Rewe Central.
And then the questions of infringement, where one's looking at, and particularly in relation to confusion, the court is looking at a different exercise, which is the global exercise. One of the features that it takes into account is the degree of distinctiveness. Now, I can quite see that in relation to the first question, the court might well have said, well, just slightly changing things doesn't really have much of an impact when you're considering questions of use. Could it be said that there is a difference when it comes to the other test, or do you say you read across the same set of principles?
I think the answer to that, my lord, comes in two parts. First, distinctiveness must mean the same thing in both of those contexts. So whether distinctiveness changes or not can't attract a different definition or a different answer in the context of those two types of assessments. Then, as to whether there is a difference between them, the judge read into, the judge's working, if you like, for his likelihood of confusion analysis refers back to one of, we're not sure which, and that's why I have ground 4 and ground 5, following the question my Lord Justice Arnold put to me. It either refers back to his analysis of the comparison of the marks, in which case you have my submissions as to ground 4, or it refers back to the distinctiveness variant use considerations at 71, and that's ground 5. So insofar as we might, even if it were true that they were different exercises, the judge has imported the exact same analysis in both cases. So that difference plainly wasn't material in the judgment.
I also note in that regard that in fact paragraph 117 contains an internal reference back, which I think Mr. Van Heegen accepted was a reference back to paragraph 71. So whichever way you look at it, you seem to get back to paragraph 71.
I think that's right. I mean, I freely say I'm having to guess, because the judge just says, as I said above, and that, as I perfectly candidly have said, that's why I have ground 4 and ground 5. Because if you're referring back to one or is referring back to the other, there's nothing else that considers this movement, and I say there's an error in each. So for my purposes, it doesn't matter which. But as to the different context of the different assessments, it can't matter because he's imported the finding directly across. I think I've covered that already. Yes, ground 6. I've got very little to say about ground 6. The first point was my learned friend took you to the particulars of claim, and then rather than reading paragraph 5, he paraphrased it inaccurately. He said that we pleaded there were 4 discrete signs. There are 4 signs there, but as I showed you earlier, I actually read this paragraph to you. Paragraph 5 says that the goodwill is associated with the business, and that it's under the signs, all of them and or each of them. So alone and or in combination. So they weren't just pleaded as discrete silos, that's absolutely not right.
I'm not sure that's how the agreed list of issues read.
No, that's fair. The agreed list, the list of issues does have the words in it, and my learned friend read those two correctly. But the pleading absolutely had them all in, and I say as a matter of principle, one has to consider, when considering each, you then have to stand back and say, what's the goodwill in the business?
Well, I understand that submission, but I do. This is not. I don't know whether your appeal will succeed or fail, but I do make a more general observation that trial judges have a very difficult task anyway.
Of course.
It's a very long judgment. On any view, seems to be a very conscientious and well-structured judgment. Even if the judge was wrong at the end of the day, we'll have to think about that. But I have to say, I feel sympathy for trial judges who decide the issues which the parties agree they have to decide, rather than having to sort of delve into the procedural history.
Well, that's certainly fair, my lord. I think putting it at the level of one word which says each sign instead of the signs it just means that actually that should have defeated what I say is a point of principle. You've got to consider it in the round. That we all have sympathy for trial judges, and I should emphasise, if it's not obvious, no part of my appeal seeks to deprecate the judge or the quality of the work he's done. Good judges get things wrong sometimes, which is why we have a court of appeal. There's no disrespect intended to this judge in any respect by any of my submissions. I just say he's got some things wrong in the course of an enormous piece of work.
I understand.
And if they're wrong, and they're wrong in the right way as I contend they are, then my lords will reverse them. But there's absolutely no suggestion of any disrespect or deprecation of the judge. It is a hard piece of work, but I don't think that a single word in the list of issues that's incompatible with the way it's pleaded would override a point of principle that I've made submissions about already and won't repeat.
I'm not sure it is incompatible, actually, because you've emphasised the word business, but it says the business of producing, selling, etc., under the signs. And the only point it seems to me you might have is the and or.
And or each of them.
That's small.
So it's the signs collectively and or each of them. That was the second point that I emphasised a moment ago, yes.
Right.
Okay.
So I just wanted to take you to it because my learned friend hadn't correctly read out the paragraph to you, so I wanted to make sure you had the real paragraph in front of you.
I had that well in mind.
I'm grateful. My learned friend misspoke when he said that I don't challenge 188 of the judgment. He's right that I don't challenge 190. 188 I of course do challenge centrally on ground 6. My lords might recall I asked you to read paragraph 188, and then I said my central submission on this ground is short and simple. It's that last sentence is a statement of principle and it's wrong.
Yes.
So I absolutely do challenge 188 and 189, which is ground 7, as my Lord Justice Arnold pointed out to my learned friend. My learned friend, though, is right. I don't challenge 190.
Right.
So finally, ground 7. The judge plainly looked at some John Lewis material. He says that he looked at the John Lewis material, but he doesn't anywhere explain why the many uses of the dark pinwheel in those stores in a major department store chain in the UK wouldn't amount to genuine use. I say if he had looked at all of that evidence...
You speak about genuine use, but that's not the right test.
I'm sorry.
The question was it sufficient to generate goodwill?
You're absolutely right, my lord. I just misspoke. Excuse me.
And
no, you're absolutely...
I'm sure you accept that those are not the same threshold.
Oh, quite so. I simply misspoke. I just used the wrong word, and I apologise. Right. For generating a goodwill, as you're absolutely right. I say it wouldn't have been open to him if he had looked at all of that evidence, given the multiple uses of the dark pinwheel on the walls, on the tables, on the swing tags, all over that stuff in John Lewis, in a major department store in our major cities. It just wouldn't have been open to him. So I think the better view probably is that he just didn't have regard to all of that. Now it might be one, it might be the other, we can only guess. Either way, the finding of no goodwill, excuse me, in the dark pinwheel, it's been a long day, no goodwill in the dark pinwheel is not sustainable on the basis of the evidence that there was before him. And of course, all of those references in the list that I've given you are ones that are in the bundle, and I would have just, if this were a 2-day appeal, I would have walked you through them one by one. I've just given you the list. There's nothing in there that wasn't before the judge and isn't in the appeal or that my learned friend hasn't had for years. So that's the essence of the submission here. It wasn't right that the John Lewis examples I rely on after the pub squash date, which was the 30th of November 2021, notably my learned friend didn't point to any and show you a date that was after that. We have very carefully checked. We do have some material in the evidence which went to other purposes, which comes after the pub squash date, and I very carefully not put those on the list that's in front of you. But all of those uses in my list I gave you this morning are before the pub squash date, which is, pub squash is a passing off case which establishes that the date at which goodwill needs to be established is the date at which the infringements commence.
Yes.
And that's why we call it the pub squash date. It just means the date of commencement and the material date for assessing goodwill. So those are all very carefully pre-pub squash and therefore qualifying uses so as to amount to establishing the goodwill. The US website materials, I say first of all, the John Lewis stuff is enough on its own. And that's undoubtedly in the case. And the judge found that there was enough trade of Athleta goods, clothing, through John Lewis to establish a goodwill. He found that in relation to the word sign, Athleta. So the volume of trade through John Lewis of Athleta products was enough to found a goodwill on the judge's finding. And I say that what that evidence shows you is that the dark pinwheel was plastered all over the stuff in those John Lewis stores. On that basis, had he looked at all of that evidence fully, he could only have found that there was goodwill in the dark pinwheel as well. As to the international website, the .com website materials, my learned friend is certainly right. If he's right about targeting and we're wrong, and that's not targeted at the UK, those materials don't come in. As I say, on my primary case, I don't need them. John Lewis is enough. But they do come in because we're right about targeting Underground 1. And in addition, they go to goodwill in relation to clothing. Of course, they came in on genuine use for bags and headgear, which is why my learned friend related them earlier. So some of those uses in the list I've given you relate to clothing, which for this purpose is enough. Goodwill in relation to clothing on the dark pinwheel would be enough to do it. My lords, unless I can assist you further, that concludes my remarks.
May I check if there's anything else?
Sorry, can I just ask one thing right, in relation to passing off?
Yes.
What does ground 6 add to ground 7? Suppose you win on ground 7. Well, then you've got points about the dark pinwheel.
Yes.
You lose on that, you've accepted that ground 6 doesn't get you anywhere.
I suppose it depends how because if I'm right that there's an error on passing off needs to be reassessed. So it would depend how the misrepresentation part were analysed then. If instead of taking the judge's findings,
Well, but your submission in opening this ground of appeal was to say you've got a finding of misrepresentation in your favour already.
oh, that's my primary position, yes. But if you disagree with me, that still holds. If you say no, there's an error, we've got to redo it all again, then I might
But
need.
as you've pointed out, there's no respondent's notice. So the judge's reasoning is no goodwill, but if there is goodwill, misrepresentation and damage. And if you prevail on ground 7, then there's goodwill in relation to the dark pinwheel. And then I suppose the question that is open at that stage is the one that was debated earlier,
Yes.
which is how far the misrepresentation finding goes, because that is perhaps unclear.
Yes, I accept that.
So there may be a question mark there. But leaving aside that question mark, one then comes to the question my lord has put to you, which is, assuming we get that far, what does ground 6 add?
Can I just take instructions very briefly, please, my lords? I think the position is it's very unlikely to add anything. I think forensically there is actually a way it could. And it's based on the lack of clarity, as my lord just adverted to, about how far it goes. If my lords were to find that it only reaches sign X, if it's the dark pinwheel, because only sign X is sufficiently close, but you would have found that sign Y was also sufficiently close if the goodwill were in the Athleta combination mark, then I need ground 6. So it's an extremely narrow set of circumstances in which I would need it, but I don't actually think it adds nothing. So it depends on how far it goes. If that's resolved by saying the misrepresentation only gets you to one sign, because that's the only one, if you were to analyse it that way, and so that's the only one that's similar enough to the dark pinwheel. But if your goodwill had been in the Athlecia combination mark, then that would have been close enough, and you would have had passing off. That is an available view when you're reassessing, I suppose, given the lack of clarity on how far it goes. So that's the only
to be crystal clear,
yeah.
where this is, the crunch point is going to come with the word sign only, so Athlecia as a word, because on the first and second combinations, the misrepresentation finding, well, I mean, question mark first, but certainly on the judge's reasoning, it must impugn the second combination. Certainly, if you're right that there's no material difference between the first and the second, then it also impugns the first. That still leaves quite a big question mark as to whether you've got a viable passing off claim based on goodwill in the dark pinwheel as against Athlecia as a word. Now, is it your submission that ground 6 would be enough to get you over the line there?
Well, it's not at all a facetious response to say, I would have to wait and find out my Lord's answer to that, which is to say, it depends what you find, honestly. It's because it is open to my Lord to find that one of those is close enough and the other one isn't. And if that's the case, then I will need to have my goodwill in the bucket of the one that's close enough. So it may be very unlikely, and my Lord will know better than I whether it's very unlikely, and I'm not going to get that answer today, and I'm not trying. But that's the only way I think it could make a difference. I accept that ground 6 needs ground 7 in order to work, but ground 7 can work on its own.
And it goes back to a question I asked much earlier today, which is exactly what the scope of 193 is, I think. What is being...
That's what we've just been discussing.
And does that... Can I ask this follow-up question then?
Sure.
Because the judge has said at the moment that he doesn't think that there's any misrepresentation by the use of the word
Yeah.
Athlecia, or however you pronounce it, on its own.
Yeah.
Supposing you're right on both of these passing off points.
Yes.
Can this court then decide the question of misrepresentation, or would that have to be remitted?
I think given the materials that you've got, and given the findings on likelihood of confusion, corrected as according to my grounds 3 and 5, I would urge, I think you do have enough. But alternatively, it would be open to you to say that you want to make an order to remit it, of course, if you feel you don't have enough. My primary position is you would have enough, based on the likelihood of confusion analysis, to correct it and then read it across. Correct it in line with, I just mean grounds 3 to 5, nothing new.
Right. Thank you.
So, my lords, unless I can assist you further, it really does conclude.
Thank you very much.
I'm grateful.
We are very grateful not only to the advocates from whom we've heard, we're well aware of how much work goes into the preparation of an appeal like this, so we're grateful to all concerned. We will reserve our judgments. Drafts will be circulated in due course to those counsel and solicitors whose details were supplied before the hearing, so they can draw our attention to any typographical or minor factual errors. We would hope that a draft order can be agreed, but if it can't, there can be brief written submissions so that an order can be finalised, we hope, at the same time as hand down of the judgment. Can I emphasise, in the light of recent judgments of this court, that the draft judgments are circulated on a confidential basis, and the court takes that embargo extremely seriously, and breach of it will be taken very seriously. Thank you very
My
much.
Lord, may I just pick up one point on that? I understand my instructing solicitors take instructions from Danish instructing agents. We would ask that they be named and added to the list, if that's possible.
What I usually do in that situation is if you can please send my clerk a list of people, if it's additional
Yeah.
to the names we've already had,
Yeah.
we need to have specific people.
Exactly.
There usually isn't a problem, but we should maintain good order.
Yeah, that will be done, my Lord.
Thank you.
Thank you very much.
My Lord, in that case, we have US counsel who are very closely engaged in this matter, so we will do the same with 2 of
Yeah.
those.
Well, similarly,
And similarly,
I'll consider that, but we need to have those in writing as well. Right?
I'm grateful.
Court rise if able.